historical event. But the fact that you go on social media and hide behind a device, whether a computer, a laptop, or a smartphone, and you go and defame someone or you produce something that's it's a current event and you are to be held liable. Turn from the mic, I show you here, mama. You see, that's why you were clapping the desk. You heard. Madam Speaker, the Honourable Member from St. Mary's Southeastern encouraged future tightening to address cumulative and organized digital misconduct and platform cooperation in fraud investigation. The government agrees with the thrust of this point. The House is reminded of the role of the major organized crime and anti-corruption agency, MOCA, in investigating and prosecuting serious organized crime, including cybercrime matters. In addition, law enforcement agencies will collaborate through existing mutual legal assistance arrangements, and as Jamaica advances its position of strength investigation. I believe, Madam Speaker, that addresses the concern of persons committing crimes against Jamaicans and are hiding overseas. We have seen in recent times a lot of persons, especially when it comes to election time. You see some people creeping out from some holes. In some instances, we see where there are paid partnerships. And that, again, Madam Speaker, can be investigated to see where Madam Speaker, the point is that they cannot hide from the law. Whether you're from Westmoreland, St. Catherine, New York, Kingston, even if you're in Algeria, the law will find you. And I'm not speaking, Madam Speaker, to any of the honorable members in this House. I am just saying areas where one that they can find security. So if you go to Portland, if you go to Haiti, the law will find you. Madam Speaker, the member from St. Andrew Southeastern raised a concern about the time taken to 2 years, in fact, to review, and of course the period before tabling. And it is indeed a real concern, Madam Speaker. The government acknowledges this concern. But it should be noted, Madam Speaker, that cybercrime reform is not a simple drafting exercise. It requires careful alignment of enforcement powers, prosecutorial practicality, constitutional safeguards, and coherence with other laws. Especially, Madam Speaker, where the amendments touch issues like consent, privacy, public interest reporting, and sensitive data, Madam Speaker. That said, Madam Speaker, the government accepts the broader point. Technology moves quickly, and the law must not be allowed to move slowly. And we are committed, Madam Speaker, to more continuous review rather than the long cycles between updates. The honourable member, or should I just say the member from St. Andrew Southeastern, raised the issue of underreported of cyber incidents, including within the financial sector. And stress the importance of reporting incidents to regulators. A very good point. You know, and it's an observation that we fully support. The Cybercrime Act itself does not create breach notification duties. So this is where now we have to teach Julia. The Cybercrime Act and it's also the Cybercrime Act itself does not create breach notification duties. We acknowledge that. But Section 21 of the Data Protection Act imposes obligations on data controllers to comply with data protection standards and to report to the Information Commissioner within 72 hours. Any contravention of that standard and any security breach affecting or which may affect personal data must be reported. That is an obligation, and I know the member appreciates that because he participated in the whole process. He participated in the process, and we have to ensure that we raise the standard here in Jamaica, where data breaches are reported in a timely manner. We have seen in a jurisdiction where there are data breaches that the data commissioner or the regulator is notified, as well as the person whose data was breached. The Data Protection Act provides that level of support and coverage. We have to now put in place the necessary enforcement to ensure that where there is a data breach, in whatever sector, financial or otherwise, that proper reporting is done. Madam Speaker, data controllers also have an obligation to notify the subjects, as I stated earlier, whose personal data is affected. And so this is a key reminder to institutions. Cyber risk is not only a technical matter, it is also a compliance obligation and it carries legal consequences. So institutions that collect data, personal data, must recognize that they do have an obligation. And where there are breaches within their institution or organization, there is a reporting mechanism that is automatically triggered and they must comply. There are very stiff penalties under the Data Protection Act. And when an institution decides that it wants to operate in this case, they must recognize that they have an obligation to protect our data and cannot use our data without consent. Madam Speaker, the member from St. Andrew Southeastern encouraged that the 2015 guidelines published by the Office of the Director of Public Prosecutions against regarding the interpretation of Section 9 be included in public education. The government agrees. Madam Speaker, a law is only as effective as public understanding and enforcement readiness. And so, proper public education must be done. And if we want to ensure that a number of our laws, in particular sensitive regulation and laws, are fully appreciated, we have a responsibility to ensure that we have adequate public education as well. We cannot just pass laws and expect people to comply. We have to ensure that the laws that we pass for the benefit of our people, that they themselves are aware of their own obligation and the consequences that will follow. Laws cannot be created in isolation. It must be done in such a way that our citizens appreciate the work that is being done to protect them. And that is why I truly agree that public education is essential. And so, following passage, we will embark on an education and awareness program to ensure citizens institutions, and law enforcement agencies understand the provisions of the Act, the practical standards, and the consequences of breach. Madam Speaker, the member from Portland Eastern asked how enforcement would define the person in control of premises and whether that person can control any act under the Cybercrimes Act. Madam Speaker, the member from St. and Southeastern also suggested mandating reports once the location of criminal activity is known. Clause 8 gives effect to the recommendation of the Joint Select Committee and is akin to a provision in the Law Reform Fraudulent Transactions Special Provisions Act of 2013, commonly called the Lotto Scam Act, Madam Speaker. Section 5 of that act penalizes the owner, occupier, or person responsible for management of premises who knowingly causes or permit the premises to be used for commission of offences under that act. Madam Speaker, it is our understanding that law enforcement has not faced difficulty identifying the person or persons responsible for management under the Lotto Scam Act. And we expect similar practical clarity here, Madam Speaker. With respect to monetary reporting suggestions, the government notes the point and will consider it as part of continuing reforms. Madam Speaker, ensuring that we build obligations that are enforceable and consistent with the existing legal duties and safeguards. Madam Speaker, the member from St. Andrew Southwestern expressed that the penalties are inadequate. The House is asked to note that the Act provides for prosecution in both the parish court and the circuit court. This creates limits at the parish court, level, but more seriously, Madam Speaker, more serious consequences at the circuit court level, where fines may be at large and imprisonment ranges significantly depending on the offense, damage caused, and whether it is a repeat offense. For protected systems where interference would have debilitated impact on national security, public services, or public safety, the Act provides penalties up to 25 years. I believe the member will appreciate the fact that 25 years, which in technical terms is a lifetime, is more than sufficient at this time. Technical lifetime. The government's view is that the penalties are substantive and sufficient, while acknowledging that deterrence is not only about maximum penalties. It is also about detection, investigation capacity, and successful prosecution. Madam Speaker, the issue of spam was raised. And I'm going to define spam as I will also define key later on. Spam is really defined as the unsolicited bulk messaging or messages which can oftentimes be a nuisance. Not yet.
Madam Speaker, members' time having expired, we ask to be extended at 10 minutes.
The question is that the member's time be extended by 10 minutes to allow for the completion of his presentation in closing the debate. Those in favor?
Aye.
Those against? The ayes have it. Minister? Please turn on your mic, Minister.
Thank you very much, Madam Speaker. Thank you, colleagues. Madam Speaker, the issue of spam was raised earlier, and we all can appreciate that spam messaging can be a nuisance. It is also a gateway for malware, phishing, and financial scams. Jamaica already addresses spamming through multiple laws. The Electronic Transaction Act of 2007, the Data Protection Act of 2020, and the existing Cybercrimes Act of 2015. Madam Speaker, unsolicited commercial communications, direct marketing restrictions, and related cyber harms are already covered within this legislative ecosystem. This bill, Madam Speaker, does not need to replicate what is already covered elsewhere. Instead, Madam Speaker, it strengthens critical gaps identified through review. And I must, thank the members and the participants who worked during the review process, members from both sides of the aisle, and the contributions that we got from the public and interest group that has brought us to this point where we can really table and debate the amendments. Madam Speaker, the member from St. Andrew Southern sought clarification on the distinction between the terms electronic and digital in the context of the amendment to the definition of key in clause 2 and 11. Madam Speaker, in modern cybersecurity practice, particularly within public key infrastructure, the PKI, a key is not simply a physical object. It is not the key that you use and start your car. And in fact, we stop using the keys that you insert in car. Right, member? It is also digital. It's not you, it is the member beside you. It refers to cryptographic key material used to control access, protect confidentiality, and verify identity through encryption and digital signatures. Madam Speaker, in today's online world, a key often means the secure code or credential that proves identity, unlocks access, or protects.
Since we developed the technology to travel
for secure logins, encrypted communications, and trusted.
job as a space colony manager is to establish thriving and
Fight a digital key. No. A digital key refers to the secure credential itself, the unique code that enables security and trust online. An electronic key now refers to the electronic device or mechanism that may hold or use a credential, such as your debit card, your credit card, a token, or other electronic tool used to access system security. Madam Speaker, the purpose of the amendment is to ensure the law clearly covers both the secure credential card and the way it is stored or used so that offenders cannot exploit a loophole. And so it was in that context that we redefined the term key relative to it. We will have to also, in time, redefine terms that now broadly covers the area. And I don't know anything about anyone else. Don't draw me into that. Madam Speaker, members raised concern about investigative capacity. While operational capacity sits within the relevant agencies, the bill strengthens procedural discipline and accountability by requiring the Commissioner of Police to develop and implement a code of standard procedures for search and seizure under Section 18. Madam Speaker, this is very much practical and necessary. In fact, complex cyber cases often succeed or fail on lawful consistent evidence handling. In addition, Madam Speaker, through international cooperation and technical assistance mechanism, Jamaica will continue strengthening training and capability across the investigative and the prosecutorial chain. Madam Speaker, the member for St. Andrews Southwestern recommended empowering the clerk of court to seize computers engaged in fraudulent activities. Madam Speaker, the House is reminded that investigative search and seizure powers reside within the Jamaica Constabulary Force. The bill, however, makes provision to improve the forfeiture process by enabling the clerk of courts to make an is about restoring and reinforcing trust. Trust in digital banking, trust in digital commerce, trust in online communications, and trust in the ability of the state to defend citizens against modern harms. It addresses, Madam Speaker, real and present dangers. The non-consensual sharing of intimate images, the rising scams and fraud targeting families and businesses, the misuse of digital tools to deceive, extort, and exploit. It strengthens enforcement while recognizing safeguards and the wider legal framework that protects rights and personal data. Madam Speaker, this is not anti-technology legislation. It is pro-trust, pro-safety, and pro-digital confidence. Jamaica cannot build a modern digital society or a modern digital economy if the public believes, Madam Speaker, that the digital space is lawless. Madam Speaker, I believe I have addressed most of the concerns raised, and I commend this bill to this Honorable House for a second reading.
As a perennial victim myself, the question is that the bill be read a second time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Amend the Cybercrimes Act and to provide rather.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause.
There are no amendment. Chair, as we're now in committee, the minister member has told that there are no amendments, so you could put the clause there on block.
Thank you, House Leader. Members, if you heard a while ago, there are no amendments. So members, I put clauses 1 through, you still want to be clause by clause? Okay, the leader of the opposition is asking that we just go clause by clause even though we have no amendments. Members, I put clause 1. He may have something he would like to comment. Yeah. Those in favor? Those against? The ayes have it. I put clause 2. Those in favor? Those against? I put clause 3. Those in favor? Leader of the opposition, do you have, if you have clauses you would like to intervene in respect of, just indicate, please. Those in favor? Those against? I put clause 4. Those in favor? House Leader, a moment, please. Members, I put clause 4. Those in favor? Those against? The ayes have it. I put clause 5. Those in favor? That's the one. Our leader of the opposition has an intervention here.
Yes, thank you. Madam Chair, it is a normal procedure to put each clause individually unless nobody has anything to say on any specific clause. And the fact that the government doesn't wish to make an amendment doesn't mean that no one has a comment to make on a specific clause. And that is why I don't think it should be suggested it's anyway obstructive to ask for the normal procedure to be followed. It's not a very long bill. In clause...
Hold a moment, leader of the opposition. In practice, the minister who carries the bill would normally indicate if they have amendments 1 and 2 would normally indicate if they would like to take the bill as a whole, which is what was done. It wasn't decided by the speaker. And
I objected to that.
I would not have been at the sitting when you made your contribution, so there's no issue if you would like to go clause by clause. None at all. So there is no difference in views. Go ahead, leader of the opposition.
I just want to revert to the issue that I had raised in my presentation in relation to the amendment to Section 9 of the Principal Act, which is set out in Clause 5 of this bill. And it creates a defense to the criminal offense where the defendant can show that the image was published for the purpose of reporting about historical events. And I said there's a lack of specificity as to what that encompasses. In his closing of the debate, the minister indicated essentially that everybody knows what historical events means. You know, when Spanish Town became the capital of Jamaica, that was a historical event. Something that happened last week is a current event. The point is, time is a continuum, and at what juncture something that is current ceases to be current is a matter that is often open to speculation or debate. And that is why, quite often, terms which have an ordinary English meaning, in English, are the subject of specific definitions in legislation, because it is recognized that the parameters and contours and limits of a concept in plain English may not be sufficiently precise for the purposes of the criminal law, which is where we are here. That is why I was seeking to have it clarified what historical events that phrase was intended to cover. I accept that something last week might be a current event. It might also be of historical importance. What about a year ago? What about centuries to to make a point, but I don't think the point was well made. I recognize the government doesn't intend to make any amendments to this bill, so I'm just using this opportunity to restate that from where I sit, it ought to have been more precise as to what the parameters of this particular defense to the criminal act of using intimate images without consent, etc., what the specific parameters of the defense are. And I just wanted to use this opportunity for the benefit of Hansard to have my concerns restated in light of the Minister's explanation. Thank you, Madam Chair.
We put clause 5. Those in favor? Those against? Ayes have it. I will take the 6 to 11 as there are those in favor. Those against? Ayes have it. I put the title enacting clause. Those in favor? Those against? Ayes have it. The question is that I do report the bill as having passed committee stage without any amendment. Those in favor? Those against? Ayes have it. The House is now back in session. I do report the bill as having passed committee stage without any amendments. Madam Minister. Minister.
Mr. Speaker, I now ask that the bill be read a third time.
The question is that the bill be now read a third time. Those in favor? Those against? Ayes have it.
A bill entitled An Act to Amend the Cyber Crimes Act and to provide for connected matters read a third time and passed.
Madam Speaker, we will now conclude the Jury Act. Shouldn't take us a long time.
Madam Speaker, in relation to the Jury Amendment Act, just a few concluding remarks.
Minister, hold on a moment, please.
Madam Speaker,
Minister of Justice, go ahead,
just a
please.
few concluding remarks before I ask for second reading. The bill itself, Madam Speaker, dealt with two issues: the increase in the fees and the widening of the fees to jurors who are called to serve, and also the matter of jury tampering before and during the trial. Madam Speaker, a number of concerns were raised, and it seemed to me, even though I've tried to remedy a number of the concerns raised in relation to jury tampering, it still needs a bit of tweaking.
So I've decided that we're going to proceed with the increase in the fees, and at the Joint Select Committee on the Jury Act, I would like the first order of business to deal with jury tampering. And we can finalize that what we have here and what would have been proposed today, but I decided we will do it when we set up the Joint Select Committee. Okay? So, Madam Speaker, having made those remarks, I know, Madam Speaker would like to ask for second reading of the bill. That bill be read a second time.
The question is that the bill be read a second time. Those in favor? Those against? The ayes have it, Clerk.
A bill entitled An Act to Amend the Jury Act, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. I'm going to go down into committee and then...
They should never have been tabled at that time. So if you had them last week, withdraw them. So, sorry? Could you, some of them, it was premature. So please, I told them not to table them. But in any event, some of them will be taken and some will be withdrawn. Okay? What, Leader of the Opposition?
I do not know that I have any copies. Yes, list of amendments. Here.
I hope members have a copy of the bill, so because we're going to be deleting quite a few of the clauses, okay? So that we only deal with the question of the increase in fees for jurors. But I told him not to table them, you know.
Minister Truck?
Yes, could you
be so kind as to take us through clause by clause?
You could go, Madam Speaker, and put the clauses one by one, and each clause I will then indicate the amendments.
I put clause 1.
No.
Minister Chuck, would you be so kind, if you have an amendment to a clause, would you be so kind as to say so prior? So I think I would prefer
no amendment to clause 1, Madam Speaker.
That you ask to put clause instead. So Minister, the approach I would prefer to take is chair, put clause 1, put clause 2. In which case I will know it has no amendments.
No problem, Madam Speaker.
Thanks.
So
Thanks,
you can put clause 1, Madam Speaker.
I put clause 1. Those in favor? Those against? The ayes have it.
Clause 2, Madam Speaker, is deleted. Madam Chair, is deleted.
Members, clause 2 is now deleted.
All in favor?
But you see, it's going to need renumbering as well.
It will come at the end, Madam Chair.
Okay. Members?
Madam Chair.
Madam Chair.
Members, the question is that we remove clause 2. Those in favor? delete clause 2. Those against the ayes have it. Clause 2 is now deleted as was previously tabled in the bill.
Madam Chair, the clause 4.
No, so
Sorry, one second, Madam. Just a
clause
note.
3 first.
No, clause 4. Clause 3, Madam Chair, delete also clause 3.
Okay, members, the question is that we delete clause 3. Those in favor? Those against? The ayes have it. Members, clause 3 now stands deleted from the original.
Now the original
table.
clause 4 to 8 will now be renumbered clause 2 to 6.
Okay. To 8. So clause 4 is now 2, 5, 3, 6, 4, 7, 5, and clause 8 is now clause 6.
Right. I should indicate, Madam Speaker. Right. So clause 3 as renumbered. And the heading should be payment to jurors.
Okay.
Payment to jurors and other persons.
So previously, clause 5 now renumbered to clause 3. The heading is amended to state payment to jurors.
Right. And in section 35 in that new,
Yes.
Clause 4, which has been renumbered as clause 2.
No. Yes.
Yes? Are you not putting it?
we did. Sorry.
No,
it
you
should
haven't
be.
put it as yet.
You haven't
But
put
could
it.
you put
You
clause?
just renumbered 4
Right.
to
Well,
8 as 2 to 6.
I was just listening to hear.
Could you put
which
that
one of the
clause 2?
renumbered clauses
I'm sorry.
are
I'm
amended.
sorry, Madam Chair. Could you put it?
All right, I put clause 2 as now
No.
stands in
Sorry,
the bill,
my fault, Madam
unamended.
Chair. Remember, we're changing payment of jurors to payment to jurors.
Yeah, but that is going to be clause 3.
Right.
The new clause 3. So I am
No,
putting the
no.
new
No,
clause
ma'am,
3.
no, Madam Chair.
Madam Chair, sorry. Clause 4 as renumbered. Now clause 2, there's an amendment. And it's to delete
so
the
the
words
clause-
and
so-
other persons from the quoted section, which is in clause 2 as renumbered.
And it should be numbered payment to jurors.
Payment to jurors. Okay.
And in that clause 35, we want to remove the next one, right? Okay.
So you're deleting the subheading. You're deleting the subheading and substituting it with payment to jurors.
So in the clauses 3 and 4, the words fees and
Hold on, Minister. Let me just put clause 2. The new clause 2 as amended has one amendment which says payment
to jurors.
jurors and other persons in court.
Madam Chair,
Just payment to jurors only. Only.
Madam Chair, that is not a part of clause
2.
as renumbered. It is the subheading, it's a heading
Is the sub-
preceding clause 3 as renumbered. The heading,
It says the
heading
principal
is
act
deleted as
is amended by deleting the subheading payment of jurors immediately before section 35 and substituting therefore the following. And then the following was payment of jurors, and the minister was saying convert it
and
to
it should be to
payment
jurors.
to jurors. That's what, right. And other persons, so, and that comes before clause 3
No.
as now.
No,
Form in the act. You can just delete this clause because you're going back to what's there now. It already says payment of jurors.